A management consulting agreement is a contract that outlines the terms and conditions of a working relationship between a management consultant and a company. In this video, we'll cover what management consultants do, what a management consultant agreement is, and clauses every management consultant agreement should include. We're eForms, the world's largest database of fillable legal forms, and we're here to help you understand and customize confusing legal documents. Make sure to click the link at the end of this video to download a template for a management consulting agreement that you can customize according to your needs. First, let's talk about what management consulting actually is. Basically, a management consultant is a professional who gets hired by a company to get familiar with its processes, systems, and policies, identify their weaknesses, and recommend improvements. The ultimate goal of management consulting is to make a company or the client more efficient. There are two broad categories this work can fall into: general management consulting and specialized management consulting. This is important to understand when you're drafting a consulting agreement because you want to be specific as possible about the work you're promising to deliver. This way, the client doesn't expect too much and you don't deliver too little. General management consulting focuses on an entire organization, so these types of consultancies aim to improve a company's strategies, culture, management, and processes. Specialized consulting focuses on a particular subset or area of an organization, such as financial management or technology management. Many consultancies involve both types of consulting. So let's talk about what a management consulting agreement should include. First, it should identify the parties it's binding together in the consulting agreement. The agreement should outline the scope of services. As mentioned earlier, this should be specific, detailed, and comprehensive. An agreement should also state the duration of the consultancy. Be specific about what date the consultancy begins and what date it ends. Include a section about compensation that outlines the type of fee structure that will be employed, as well as acceptable methods of sending and receiving payment. If the consultant is eligible to be reimbursed for expenses, the agreement should clarify this and specify which expenses qualify for reimbursement. Let's turn our attention to some other clauses that are important to consider when you're drafting your management consultant agreement. First, will the consultancy involve a retainer? A retainer is the amount of money paid for the consultancy upfront or before any actual consulting work begins. Often management consultants who charge retainers base their pricing on their standard hourly rate, but at a discount. The idea is that swallowing the discount is a small price to pay for securing payment in advance and some stability going into the arrangement. Next, will the consultancy be contingency based? Contingency fees are common in the legal profession. Many lawyers don't get paid unless they deliver results or win cases. What a lot of people don't know is some consulting arrangements involve contingency fees too. This means the consultant gets paid when specific targets are achieved. If this fee structure will be used in a consulting agreement, the agreement should be clear about pricing and the nature of the goals that must be achieved before the fee is paid. Agreement should also contain a confidentiality clause. While getting to know and analyzing a company's internal systems and processes, it's likely a management consultant will come into contact with confidential and commercially sensitive information. This may include financial information, business practices, technology strategies, marketing strategies, or other types of information belonging to the company or its customers and suppliers. Building a confidentiality clause into an agreement helps to clarify each party's expectations around the use of sensitive information for the duration of the consulting agreement and beyond it. The last clause we'll discuss is an indemnification clause. Clients, particularly large companies, typically ask consultants to include this in contracts. This basically shields the client from liability in the event that they get sued as a result of errors or mistakes in the consultant's work. So when the client demands indemnification, remember you can request indemnification in certain situations or come to an agreement about which liabilities each party will carry. For example, you can agree to indemnify the client if you breach intellectual property laws and get sued, but you can ask the client to indemnify you if they do something wrong. This way, each party accepts responsibility for their own actions. Remember to hit the link below to start creating your own management consultant agreement. And don't forget to subscribe to our channel for more videos that break down complicated forms so you can spend less time trying to understand legal matters and more time on your actual work and life.